Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number 1 CV18-0403. In re the marriage of Rakesh Malhotra versus Neera Malhotra. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your clients at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and we have discussed the case in conference. So, counsel, with that, you may proceed.
Your Honors, may it please the Court, Al Arpad for Appellant Neera Malhotra. And I'd like to reserve, let's say, 4 minutes at the end for rebuttal if I could, although I don't have anything near a 20-minute speech planned. I requested oral argument primarily because it's a very large and unwieldy record, and I thought you might have questions for us. It can be confusing. This portion of this case started in 2013 with a petition filed to enforce a term of the decree about a retirement plan in the husband's former medical practice. At the beginning of it, most of the fighting was about control and trying to get information. Trial counsel had dropped out about a year after the decree, and new counsel, Dan Zanin, had come in, and later I came in. And frankly, we didn't know what was going on. When we eventually did get the file from trial counsel, it consisted of 23 boxes, and so sometimes we still didn't know what was going on without having to look through the entire 23 boxes. So at the beginning, the pleadings are a little unfocused. And I think that explains one of the things that has been brought up by Dr. Malhotra over and over again, is that the original petition says all of the assets in the SMA, Saguaro Medical Associates plan, belong to wife. Well, as soon as we had a chance to look at the documents, we realized that not all of the assets, just the community assets in the plan, were supposed to belong to ex-wife. And that's been our position ever since. So to the extent that that argument is based on the fact that the original petition said all assets, that's kind of a red herring. Our position is and has always been since we figured out what was going on, that all of the community assets were awarded to ex-wife in the decree.
There were values given to the assets that were awarded.
Yes, Your Honor, and I think that's really the critical interpretive question for you. That's the thing that you have to decide in this, whatever else you decide. You have to decide whether the assets language in the decree means that the whole assets were awarded to my client, or whether the value money, whether the values that were given mean that only the values were awarded to my client. Now, what that leaves you with is two possibilities. If the assets were awarded to my client and there was a mistake in valuing them, then they belong to my client, and she should get them all. If the value language is controlling, the only conclusion that I've been able to come to after looking at this for a very long time is that you've got an omitted asset which consists...
Omitted or admitted?
Omitted. It wasn't disposed of by the decree simply because the judge didn't know that the retirement plan assets, you'll recall this is late 2010, early 2011, all kinds of assets were going up at that time because they'd gone way down a couple of years earlier. And so the judge simply didn't know that the assets had increased in value during the course of the almost 5-month trial.
If we use a definer like 100%, how do we get away from that? How do we explain away the part that isn't hers if she gets 100%?
Well, I don't explain it away. I rely on the fact that the quadro says 100%, and that means 100%, and my client should get the whole thing. And Dr. Malhotra gets the balances in the plan minus 100%, which is none of it. Does that answer your question? Or
100%.
Thank you, Your Honor.
Can I ask you, you mentioned the assets and SMA plan. And looking at the decree as I read it appears to identify $12,000 in cash, some stocks and bonds with a value of $572 and change, cash value of the life insurance policy, and then there's a fractional interest of land in Gila Bend, which I don't believe is part of our appeal here.
That's true.
What other assets were in the SMA plan that weren't? Is that all of the community assets from your client's position in the plan?
That names all of the community assets, and that is in fact a fairly accurate valuation in August 2010 at the beginning of the trial when the parties put in their pretrial statements. So if that list of assets is all of the community assets. Now, at one time, this was a plan that had substantial number of participants, other doctors, other staff, so on and so forth.
But, and then you mentioned that there were, in describing your early filings in the case, that there was a reference to all assets and that over time was refined to community assets only. How would we divine those two universes?
By the time these proceedings took place, the assets that were in the plan, and they're essentially mentioned in the quadro, are those community assets that are mentioned in the decree, and then there's another account that contained $40,000, $50,000 that Dr. Malhotra had deposited after the petition date, and that's that account 2772. And Mr. Zanin and I didn't know that when we first took over the representation, but we eventually were convinced that that's what that was, and so we said, okay, the quadro appears to be correct, 2772 belongs to him, and the rest of the stuff belongs to us.
So the only non-community asset at the relevant time here in the SMA plan was the account 2772 that had a balance 40 to 50,000 somewhere in there.
I think that's correct, Your Honor. I've never seen anything, and there are lots of account statements and other things like that in the record that tell you there's nothing else there. And in particular, if you look at our cross motion for summary judgment, it's got a couple of account statements from the Wells Fargo from the Wells Fargo account that are attached to the statement of facts for December 2010, I think it is, and May of 2011. And if you look at the front of those, you can see there's a summary, and it tells you, has anything else been put in here in the meantime? And it's not there. There just isn't anything. The assets are the same assets that were in there at the beginning of the trial. Well, I shouldn't say they're the same assets. There's some churn in the Wells Fargo account. There's some things that are sold and replaced. But it's essentially the same account, and there's not new money coming into it.
Okay. Thank you.
I don't have a great deal else for you. Dr. Malhotra's theory of this case has never been clear to me. And so to the extent that
Can I interrupt you there? I want to hear what you have to say on that point. But you mentioned this other account, 40 to 50,000. That's different than the $50,000 that's referenced as having been withdrawn by husband in May of 2011. Is that
yes,
correct?
there was never an evidentiary hearing to attribute motives or anything like that. But I think it's frankly pretty apparent that Dr. Malhotra figured out at some point during the trial or towards the end of it that there was going to be this excess slush fund, and he removed some of it. So there hasn't been, as I said, any kind of an evidentiary hearing about whether that was a bad act or what it was. But the $50,000 was taken out of the community account. I don't think that's disputed. And it's in fact accounted for in husband's version of the way things should be divvied up at the end, which is what Judge Thomason adopted.
Is that IR 517 Exhibit 1? Is that? And
I think that's true.
Any sort of clarity on that point would be helpful to me, just because I want to make sure I'm working off the same sheet of music.
Sure.
From your perspective, that was money taken after the entry of the decree that was not contemplated by the decree.
That is part of what we defined as the disputed funds. So the funds went up by about $150,000 over that time period while the trial was going on. And then there were some additional funds awarded because at the end, ex-husband proposed, well, you know, ex-wife had 90% of the funds that were awarded. Then there's this other amount that was 10%, so I should get 10% of the increase that happened post-decree because, does that make sense to you? I did a little diagram. I think that's one of the things that Judge Thomason really had difficulty with because, frankly, in the early stages, it did not occur to me that the two phases of appreciation were going to be legally treated differently. We were just saying we're entitled to the assets, we're entitled to the appreciation. if you take the view that the values are controlling in the decree, I don't think they are, but if you take ex-husband's view on that, that means that this appreciation during trial simply wasn't known to the trial court, wasn't accounted for. Dr. Malhotra has made some procedural arguments about what we need to do in order to divide that up. Frankly, I think it's squarely within the petition, and you've got the ability to just say, here's what should happen to it. But if you feel we need to go back and file a motion to reopen or something like that, we can do that. What has to be resolved, though, is what does the decree mean?
Your view is that the decree awarded your client assets, not values, not fungible money, but literal assets in an account, correct?
That's correct. And to the extent there's a mistake about valuation, it's Dr. Malhotra's problem, because he was the one who was in control and he's the one who could have fixed that.
Okay, so when did you?
Let me, just to finish that line, those assets, though, no longer exist in that plan, correct? It's been liquidated?
I believe that is true, Your Honor. I have been representing my client in a limited capacity. She went through a bankruptcy and everything else, and so it technically was still in the plan and was frozen in the bankruptcy, and it's what would be called an orphan plan. If you have all kinds of problems when you don't have a business and you have a plan that's supposed to be attached to a business. And frankly, that's why you've never seen anything much in the record about the $14,000 cash, is because those kinds of plans are kind of expensive to administer, and $14,000 disappears pretty quickly.
No, the point of my question, though, was if your client's position is you get the assets of those and the assets are still in the plan, I get what you're seeking. But if they're no longer in the plan, it's a money request, not an asset
At this point,
request.
it's a money request, and I believe the position my client would take for tax purposes. I think what her plan was to roll it.
And I'm not looking to get into tax, believe me. I would be delighted to not be into tax, but I'm just trying to get a feel for what your client's requested relief is and what is possible and what is not possible.
My client's requested relief is that the money has to be paid back. I don't know whether Dr. Malhotra currently has the money in a plan so that he'll do a plan-to-plan transfer, or whether he's just going to have to write a check.
But it's a request for money, not a request for the delivery of the stocks, the
That's
bonds.
true.
Okay.
That's
Now,
just
I interrupted
money.
Judge Cruz in following up on that, and I apologize, really.
No, not a problem. So, all right, so just so that we're straight, when was the first time that husband disclosed to wife the value of the assets?
Never. To this day, I think you'll look in ex-husband's answering brief, and he's still not really telling you, here's what this money is, here's why it should belong to me.
So how before trial, at some point, you learned what was in the SMA, right?
There were lots of, well, I didn't, but the prior counsel got big discs full of many, many documents, including statements that went up to July or August of 2010.
So what I'm trying to get at is how the Superior Court came to the amounts that it assigned wife.
Through the course of this litigation, we spent a great deal of time looking at those statements, finding the ones that were in gaps that we didn't have, so on and so forth. Counsel and I stipulated to some facts over the summer of 2014 that then resulted in those cross motions. At the end, you will see two documents.
So did you stipulate to these values?
Not to these values as such, but essentially that various things had happened, and then we both had the account statement, so you could see that new money hadn't come in and things like that. But then you have EIR 499 and 504, which are essentially the competing versions of how the money should be split up. And what the court did was adopt Husbands. And Husbands was based on a document that's attached, I think, to our opening brief. It's just a one page, and it says, here are the balances, here's how much should go to my client, here's how much should go to Mrs. Malhotra.
Okay, so it's based on Husband's statement of the balances.
Yes, I don't think the balances are disputed. It's just a question of there's a difference between the beginning of trial valuation and the end of trial valuation, and that difference is the only money at issue,
right,
plus some increase on that.
Right. So I was starting with the first question, which is the initial amount was based on husband's disclosure, and wife did not object to that amount.
Right. Both pretrial statements contain dollar amounts that are within a modest, so small that given how much the value was changing over time, it didn't matter. You could tell which statements they were based on if you looked at them. And then during the trial, I think in January, husband got up and essentially took the exhibit from his pretrial statement and said, are these the values in the account? And he said yes. And that already was not entirely accurate, but then it went up even more after that.
Okay. And so did wife ever ask for updated values
I honestly
before the decree was finalized?
I don't believe before the decree was finalized.
Or before the trial was over, better.
There was a lot going on, and I can't guarantee you that there's nothing in that 23 boxes. But if you look at what happened in the course of 2011, there are a whole bunch of emergency motions and things like that that get filed because my predecessor, trial counsel, was outraged when she discovered the $50,000 had been removed and some things like that.
And so do you ask at that point, what are the current values on the accounts? What are the current balances?
She got account statements, and so she did know the balances, if that's what your question is.
So she knew that the value,
yes,
that there had been appreciation.
And she went into court and said, Your Honor, these belong to us. And actually, if you look at the various orders, they're consistent with the court saying, yeah, those belong to you. For instance, there's that October 2011 order that says you get the life insurance policies. It looks like the court's treating them as assets. But there's nothing really conclusive, and then a conflict arises between trial counsel and my client towards the end of the year, and she disappears and gets replaced by people who don't really have 100% grip on what's going on at that point.
But all that's post-decree.
All of that's post-decree.
And was she getting monthly statements pre-decree?
There were a lot of – Dr. Malhotra was in control of the plan up until we, through the bankruptcy court, essentially took over control of the plan and started getting the statements. So it was difficult for us to get statements up until that point. So we didn't actually know what was going on.
So when was the first time you learned there had been the great appreciation?
As I said, in the first round of motions, it would have been – the first thing that happens is there's a fairly quick – at the end of 2010, there's a fairly quick hearing in which we said, Your Honor, we still don't know what's going on here. And the court said, okay, we're going to a discovery master. And not too long after that, we got the statements. So we're talking about beginning of 2014, if I'm remembering this correctly.
Okay.
You had mentioned the latter part of 2010, and now you just mentioned 2014. I want to make sure I understand the years because it seems important.
Throughout 2011, the parties are fighting like cats and dogs over attorney's fees is an enormous issue. They're going to have an attorney's fee hearing at the end of the year, but also over these pension plan. Trial counsel falls out of the picture. Actually, let me...
And let me, just so we're clear, I think what I'm really asking for is during the first 3 or 4 months of 2011, if your client was getting monthly statements.
My client, I don't believe, was getting monthly statements, although I don't know that for sure, but my client did get a subpoena response, which appears prominently in the record, so she had statements that showed her that, in fact, there had been some increases, yes. And throughout that time, her position was that belongs to us because we were awarded the assets.
I want to be real clear on something, particularly when we're talking about the assets that are assigned by the court to NERA.
Yes.
There is the original value of the account or the asset, correct? There's appreciation on the account or the asset. But there was never a time from the time that those assets were awarded that additional principal was put into those accounts. Is that correct?
I believe that's absolutely true, Your Honor. And
so anything that would be in those accounts or a part of those accounts would either be what was ordered, given to your client, as a portion of the value of the asset being assigned to her, or the appreciation on the asset in and of itself, not because additional monies were fueled into the account.
Absolutely correct, Your Honor.
Thank you.
And you could see that both in those statements that I mentioned, and then there's also a spreadsheet that is in one of the very late documents that gets filed, and then I believe ex-husband kind of pulls numbers from that to do his little mini spreadsheet that is used to divvy up the money. I'll reserve the rest of my time if I could. Thank you.
All right.
Thanks.
May it please the court, I am Lonnie Williams, and I represent the appellee, Rakesh Malhotra. There are a number of things that you have been provided and told here that are not supported by the record. And we need to start at the beginning. The court at trial made a very definitive statement. It said that at trial, certain things were undisputed by the parties. And it doesn't talk about the assets in the plan. It talks only about the community property assets in the plan.
Counsel, isn't it true that when the court made the awards, it said 100% of?
No, there's no evidence in the record to support that. The decree was filed in 2006. We're in trial in 2010 through 2011. The issue they are now arguing in terms of what happened to the account was not argued at trial. There was never a petition to reopen the decree. And they are, when you look at their statements, there are letters from counsel and all kinds of things that they're trying to justify post-decree to answer the question you asked, Judge Jones, that nothing was ever put in there. There is nothing in the record to support counsel's statement.
So we're real clear. You're saying that even after those assets were assigned to Mrs. Nira, Rakesh, that people just continue to put in assets and take out assets?
No, I'm talking about pre-decree. There's a 5-year period,
Right.
maybe 4.5 period, where we know they've stipulated that money, at least one addition was made to the plan. And what I am saying is you have to look at what happened at trial. And at trial, and the court was very clear, it's undisputed that certain assets in this plan are community property. And the court lists them in detail. But the court doesn't stop there. He takes those assets and uses them to calculate spousal maintenance. Under their theory, you'd have to literally reopen the decree.
Let me stop you for just a second before we get too far. So if the court found at trial that it was undisputed that the SMA pension plan was community property, you're telling me that not all of the pension plan was community property?
I am exactly telling you that, and the court's telling you that because the court says it was undisputed, quote, the following assets titled in the SMA pension plan were community property. And then he goes on to list what assets are community property. And he says that's undisputed. We have the community property in the record at trial. Counsel's telling you now that they were somehow misled.
Let me ask you another question. So is it your representation that aside from those assets specifically listed by the court, there were other assets
Yes.
in the plan?
Yes. And that's the way it's worded.
And what are those?
Judge, I could not give you those because it's never been developed in the record because it's never been an issue from my client's standpoint.
Well, it's been an issue because the court said, let's see, give me just a moment. The court at one point says that we don't know if there's anything else in there,
You're talking
that there's any other asset.
You're talking about in the first ruling before the ruling of February 9th, 2015?
Right.
I agree with you. But again, I'm going to get far afield because in that ruling, the trial court literally said, I don't have enough evidence to support the petition. and therefore I'm going to send it to a special master. We've always believed that if you don't have enough evidence to support a post-trial petition, that means the petition is denied. But I don't think that's relevant because no one's appealing for that. What we have is the beginning of the trial and counsel saying that they did not have the ability to conduct discovery to find out before they stipulated. Because again, the trial court says it's undisputed.
What I'm having a hard time understanding is how you, husband, cannot conclusively say this is what else was in the plan that is not community property. I mean, if you're representing that only a portion of the SMA pension plan was community property, I think it should be fairly straightforward for you to be able to say this portion right here that I can identify is not. And you're not telling me that there is or isn't. You're just saying we just don't know.
No, Judge. That is not what I'm saying. I'm saying
Okay.
everything in the SMA plan as of the time of trial, other than the specific assets that the court found were community property, were not community property.
Right, and I'm saying, what is that?
You want a number?
No, I'm saying,
No, there were other stocks. There were other accounts. It basically consists of accounts, mutual fund,
and do you
stocks.
have a record? Do you have which record on appeal that is? How we look at that? The list of that?
We do not have anything in the record that supports my opponent's statement in terms of the amounts, because that record was never developed, because the issue raised by the petition did not call for that. And this is where we get confused in their current position.
Well, but the question of what was community property versus sole and separate property was a question at trial.
At trial. But at trial it was decided. It was decided that it was undisputed, and no one...
Wait. It was disputed until you went to trial. It was decided at trial, and that was undisputed?
No, the trial court, based on the trial testimony, found that the amount of community assets in the SMA plan was undisputed. It's right here in the decree. Mm-hmm. And so that's where we start, because that's the trial court's finding in 2011. No one has ever sought to open that up for any reason whatsoever. And we have to remember why we're here. We're here on a petition for post-trial relief that specifically raised the issue that all of the SMA assets belong to wife. When Judge Thomason ruled on that issue on February 9th, 2015, he tells this court and us what the issue he's deciding on the petition. And we all know under the former version of Rule 91, you had to be specific when you were filing a Rule 91 post-trial relief. And they were. They wanted all the assets of the plan. And that was the issue Judge Thomason decided. And he decided it clearly. He said, no, the decree is clear. Not only did the judge award specific amounts, he used them in his equalization, he used them for spousal maintenance. There has never been a Rule 85 or any other mechanism to say, Judge, you were wrong, trial judge, when you said that the community assets were A, B, and C. What they want now is somehow, through this petition for enforcement, to reopen the decree. And what we're saying to this court is those are two different things. Here's what I would suggest. How can this court reconcile appellant's position with the portion of the decree cited on page 5 of their opening brief, where the court says it was undisputed at trial that these assets, how can you reconcile their current position with that statement. You cannot. The remedy, if you at some point think that's wrong, it's not to file a petition to enforce. It's to go back and open it up and go through that process under Rule 85. What the petition asked is whether we had it all. After they realized they were wrong, they've changed their position. Similarly, they've never asked for the equitable relief saying that these are undivided assets until literally this appeal. They never sought to go in under Rule 85, as the case law dictates, and say, Judge, we believe there's unallocated assets. It's never been done. So the court needs to focus on why we're here. We're here because Judge Thomason, on a petition, decided that they were wrong in saying that all of the assets of the SMA plan were awarded to the wife. And he clearly, on the first page of his ruling, says she's wrong on that. And based on that, he takes the asset she was awarded and gives appreciation based on the date of the decree, and that's what was awarded to her. The same thing as if we have with the insurance policy. They, in various pleadings, say, well, she got more than cash value. And we say, no, she didn't get more than cash value, because there's no question that the cash value of the insurance policy at the time of trial was more than $290, because somebody had to continue to pay the premiums between 2006, the day the community ended, and 2011. So what the judge was saying is the one thing the parties agree on is what's community property. And you cannot reconcile their position without opening that up.
Counsel, let me ask you, in the decree, on page 9, it does reference the specific, or maybe page 10, and you've quoted from it, I think your opponent has as well, the specific buckets of community property, and then that reference to the Gila Bend land. Where in the decree would I find a reference to SMA, pension, or profit-sharing plan assets that aren't in the community? Okay. I didn't see it, and I just want to make sure.
It is not in the decree, and it's similar to the Cupert orders that came after. When you think about it, there's no reason why they need to be in the decree.
And I understand that.
Correct.
It is not subject to division if it's not community property.
Correct.
It just, as a stranger to the decree, it would have been a lot cleaner had there been a reference to, oh, there are other assets. Those are...
And I would say, when you look at the Cuperts that are part of the records that we believe are consistent with the decree, you see that the Cuperts are very clear that they are awarded the assets referenced in the decree, and my client gets the difference. And there's no way to reconcile the orders they submitted. And I know there was change of counsel, but they submitted those orders. The trial judge changed them, because one of the things that's clear in the record is they submitted an order that said, I get everything. Trial judge says, no, what you get is what I said in the decree. And then the Cupert that they submitted says they get that, my client gets 100% minus what they get. And that's the record. So again, I ask this court, when you have 3 orders, all consistent, and they now say that was all wrong, how do you seek relief? Not through Rule 91 to enforce, because the decree is clear. She was given assets with specific values. They were used throughout the decree. If they think that was wrong, they had remedies, and they chose not to exert those, including filing a motion for relief under the statute saying there was undeclared assets. We're the only one who has cited to this court the Ringler case that sets forth how you do that. And that was a case right on point, because the issue was there was saying, no, they don't, the family court doesn't have jurisdiction. And the court said, no, they do. They have jurisdiction under Rule 85 to consider that issue. They don't have jurisdiction under Rule 91, which is so limited in its purpose. And they could have at any time. And if you ask them, they will not be able to cite anything in the record where they made that request, except one thing. They will tell you that in their second petition, they asked for any other relief the court deems appropriate. In other words, they're telling you that what we all put in every single complaint we file is, in essence, a free license to amend, to argue anything we want. They don't have the basis. They didn't file a new lawsuit. They didn't seek that relief. And they didn't seek to reopen. This really is a case where they disagree with what the trial court did in terms of the petition. The decree. They never attacked the decree by way of appeal. They never sought to appeal the Cuperts, which were final orders. Then we have 2013, and all they said there is all of the assets. So what they're trying to do is take that petition and get back to attacking the decree. There's just no procedural or legal way they can do that. The decree stands, and the court's statement of what was undisputed stands, and they can't attack that. And with that, unless you have any other questions, I would simply continue to ramble, which I don't want to do.
Thank you.
Counsel made a couple of references to a Cupert. There was something called a Cupert in this case at one time, but I think he's referring to the Quadro, which is the order that distributes the assets. Is that correct, Mr. Williams?
Yes.
Thank you.
The Quadro, I agree it's pretty clear. It says 100% of the total account balances of the participant as set forth in the decree of dissolution, excluding one thing, this 2772 account, which we, once we got access to the documents, promptly agreed, you're right, that's post-petition property, you get to keep that. It is absolutely in the record what was in these other things, what was in the Wells Fargo account. At the start of trial, those balances match up. And what was there at the end of trial, and there haven't been any contributions made, it's all just appreciation on the original assets. That's in the record. As far as the technical issue goes, our petition was absolutely consistent with our theory of the case and with the remedy we were asking for to start with, which is that we were awarded the assets. Please give us the assets. If you adopt ex-husband's interpretation based on values, then we say, well, it has to be split. If you determine the way to do that is that we have to go back and file a Rule 85 motion, I think it's well within the pleadings we've got here, but we'll go back and file a Rule 85 motion. You do need to tell us, I think, what the decree means so we know what to do and can wrap this up promptly one way or the other.
Thank you.
Thank you.
Counsel, we thank you for your arguments. This matter is now taken under advisement. We will issue a written order in due course.